Hey everyone, welcome back to today's video. We're wrapping up a case I've been following for a few months now involving a sovereign citizen out of Kansas named Abel Estrada. I honestly didn't think he could top the nonsense from his first couple of hearings, but then he basically said, "Hold my wife." Let's get into it.
Are on the record in case number 2024 TR 617, State of Kansas versus Abel Estrada Jr. Paulie Dean for the state. This is 2024 TR 617. Mr. Abel, you need to start your video and audio. Mr. Abel, you need to start your audio and video so we can have your bench trial.
Here. Hello. Here. Hello. Hello.
Mr. Abel, you need to start your audio and video. Sounds like you've started your audio.
Yeah. The video. Start video. Okay.
All right, Mr. Abel, you are representing yourself today, is that correct?
Yes.
Okay.
Judge, you never approved my order for withdrawal.
Yeah, you set that over for today.
Well, I do have your motion to withdraw. I also have the defendant's pro se motion to dismiss with extreme prejudice, affidavit of true and affidavit of reservation of rights, request for writ of discovery, which he filed November 21st to 24. Mr. Abel, what's going on between you and your attorney? Do you want an attorney or do you not?
I do, but he's not able to defend me because for the interest. I don't know, but he's not defending me. I need an attorney.
You say you need an attorney?
But you know.
I don't know if it's your computer or mine, but I'm having a hard time hearing you, sir.
Hello.
Missy, is that his computer or mine?
I hope it's not mine.
He's not sitting close enough to the microphone, Judge.
All right, you need to sit closer to your microphone is what I'm told, sir.
Can you hear me now?
That's great, yes. Now, what's going on with your attorney? Do you want your attorney or not?
I do, but there's some conflict of interest where he said he's not going to represent me.
He says he's not going to represent you?
He says he's going to pull himself out.
Okay, Mr. McClendon, what's your take on this?
Judge, my client wants me to support a position that I believe is contrary to the Constitution of the United States, and I took an oath to uphold that when I became an attorney, and I take that oath every year, and he's wanted me to pursue this position that I do not feel comfortable representing the law.
Your Honor, this is the same issue. I believe Mr. Paul was first appointed to this case. Essentially, the defense, as the court has seen, is one that's contrary to the United States Constitution, Constitution of the state of Kansas, that he's, for some reason, is exempt from, as a private citizen, from the laws of the state of Kansas.
Well, aren't we going to have the same problem regardless of what attorney he has?
That's correct.
It really doesn't matter what attorney he hires, because no lawyer is going to agree with his claim that the Constitution somehow gives him the right to ignore every law in America or avoid the penalties for breaking them.
If my understanding is correct, the court has indulged Mr. Abel in that it's appointed him two attorneys now. Two attorneys he sought to have basically present a defense that's contrary to the Kansas Constitution, contrary to the oath that each attorney takes when they're licensed with the state, and additionally, this carries a maximum sentence of 30 days, which would typically not even make him eligible for attorney, but the court has taken the effort to give him counsel.
Well, and didn't Mr. Estrada, didn't this attorney, William McClendon, represent you when this was brought in initially in city court?
Yes, and it was dismissed. This is why I'm claiming double jeopardy, because I'm going for the same case over again, and this has been dismissed already. Why am I going to court again?
Well, you didn't actually go to trial in the other one. You had a first appearance, as I recall, and then it was dismissed. So you haven't had any jeopardy attached. You've not had a trial in this.
Well, the supremacy laws says that you cannot be tried or convicted of anything.
I know what they say. All right. Well,
Listen to your words, sir. You just stated it. Tried or convicted. The jury was not impaneled. The judge had not begun to take evidence in your city court case. It was dismissed. Jeopardy does not attach until one of those events occurred, and they have not occurred.
So Mr. Abel, if you want an attorney, it's going to be William McClendon. If you don't want an attorney, you'll have to either hire one, which it's kind of late for that today, or you'll have to represent yourself. So which way do you want to go?
I like to get an attorney, but
Well, I'm not going to give you continuance for it because you've had this case in municipal court, you've had this case in this court, you've known this hearing was coming up, and you've gone through 2 attorneys. So what do you want to do? Are you going to represent yourself or use Mr. McClendon? Those are basically your choices.
I want to be, but the paperwork
you have to stay up by the microphone. I can't hear you.
I want to be represented by my attorney, but the paperwork that I support, that I put in there, is completely lawful, and he doesn't want to go forth with my paperwork.
So here is that where the disagreement is? You filed this voluminous motion to dismiss with extreme prejudice, as you captioned it, and he doesn't want to argue that for you? Is that why you 2 are in disagreement?
Yes.
Amongst many other reasons.
I love how the attorney jumps in just to remind the judge that a disagreement over constitutional interpretation is just one of many reasons he shouldn't represent this defendant, alongside, apparently, a debate over the nutritional value of windows.
I'm gonna
Judge, if he's able to draft a motion of such, I don't see why he can't be able to argue it himself.
Well, I'm going to have you stay on board, Mr. McClendon. And Mr. Abel, I have read your motion. Believe it or not, I did read it all. I read about your arguments for the 6th Amendment right to counsel and your discussion of Attorney Richard Paw having a case conflict. And then you start talking about your commercial and private license plates. You start citing federal law that isn't even applicable here.
How's that?
And you start getting into the U.S. Code. And you start talking about retaliation and coercion and the right to confront witnesses, which I agree you do have, and they are here to testify, as I understand. But I don't agree with this, what you call lawful private American righteous onto the Lord, the King of glory, and the law of the land of the United States. Ex parte Milligan, that isn't even making any sense. You start talking about military courts. This is not a military court. You start talking about being a free person, having the right to travel on the roads. Well, provided by their servants for that purpose. Well, we don't have servants in that sense. People are not servants unless they're hired and appropriately contracted. But as far as the roads, if you don't see yourself as having contributed to making those roads,
I love how the judge basically said, if you didn't help build those roads, then you don't get a say in the rules for using them. In other words, if you want to paddle down the street in your road canoe, without being bothered by so-called road pirates asking for a license, then you'd better buy some land and build your own damn roads.
you've included a dismissal from city court. You argue that the U.S. Supreme Court and other high court citations prove that no license is necessary for normal use of an automobile on common ways. That's not right. That's not the law. You talk about yourself being a traveler on foot, but you weren't a traveler on foot using the public highways. You were driving a motor vehicle according to the allegations. You attached something from a Nora-Weisenberg Foreign National Division, and you addressed Governor Pat McCrory out of Raleigh, North Carolina, a 2015 letter with a carbon copy to Deputy Justice Attorney General Loretta Lynch and Secretary of State John Kerry. I don't see that having any relevance or bearing. Then you've got something with a copyright number and a fee schedule with lawful legal notice, as you call it. And you start talking about prohibited actions in 18 U.S.C. 101, 18 U.S.C. 241, and you go down through those. And again, this is not a federal court. And then you start talking about you have fees that the officers must pay before they can do any business with you.
Correct.
And if they refuse to pay your fees, then any business or interaction with them or transaction you say is basically void. And I do not find that that is the law. You have an interesting fee schedule attached. Apparently, to give them your name, you charge $50,000.
Correct.
To give your driver's license number, you charge the officers $50,000. If they want your social security, it's $100,000. If they want a retinal scan, is that $5 million?
That's correct.
Fingerprinting, photographing, $200,000 each. Then DNA and a bunch of that stuff is $5,000, and you go on with like a long list of what